there have been some examples of situations where athletes have been taken advantage of, especially early on when NIL became a thing. People were excited. I can make money now off of my NIL, so I'm just going to sign whatever someone sends to me. I'm not even going to review it. I'm going to get free stuff. I'm going to get money, so I don't care. I'm just going to sign. And if you do that, there are some examples of athletes signing deals that went for a very long period of time. They were signing over lots of their NIL rights, maybe exclusively to this company or exclusively for a certain category. And if you would have had someone that knew what they were looking for help you review that agreement, you wouldn't have had that stuff in the agreement.
Welcome to Mitlin Money Mindset, your weekly dose of inspiration and insights to ensure you enjoy each step of your journey. Whether you're saving for the future, planning your next big adventure, or simply looking to add more joy to your life, you've come to the right place. Now, let's dive in.
I'm Larry Sprung, your host for the Mitlin Money Mindset and founder and wealth advisor of Mitlin Financial. Today's guest is Mitt Winter, an attorney at Kennyhertz Perry. Mitt Winter is a respected attorney with an extensive experience in sports law, business, and litigation. As a member of the legal team at Kennyhertz Perry, Mitt advises clients on a wide range of issues, including sports business matters, NIL regulations, and business transactions. His in-depth knowledge and practical approach have made him a go-to resource for athletes, entrepreneurs, and organizations navigating the evolving landscape of sports law. With a background as a former Division I college basketball player, Mitt brings a unique perspective to his legal work, understanding firsthand the challenges and opportunities in the world of sports. He combines his legal expertise with a passion for sports to help clients achieve their goals while staying compliant with the ever-changing regulations. Join us as we explore Mitt Winter's career, discuss the current trends in sports law and NIL, and learn how his work is impacting the future of sports and business. Well, I have the pleasure today of being with Mitt Winter, an attorney at Kennyhertz Perry, and his expertise is sports and NIL, and we're going to be talking about that. You know how we love talking about joy. We love talking about sports, and we'll talk a little bit about money here today as well and how that is affecting athletes. So welcome to the show, Mitt.
Yeah, appreciate it. Thanks for having me on.
Yeah, it's a pleasure to have you here. And, one of the things I like starting out with, because I feel like people's journeys are so interesting on how they end up where they are. So if you could take a few minutes and share your journey to, becoming an attorney and working at Kennyhertz Perry and why you chose the field that you chose.
Yeah, I didn't grow up always wanting to be an attorney. Like, some people see TV shows where attorneys are doing their thing and think that's really cool, or they have parents that were attorneys. That's not my story at all. I grew up in Topeka, Kansas, and got recruited to play basketball at William and Mary, which is a Division I school out in Williamsburg, Virginia. So went out there, and when I went to college initially, my plan was to go to med school after undergrad. So I took a lot of science classes my first couple of years. Started off with a biology major. So a lot of biology classes, some chemistry classes. And when I started taking a lot of these chemistry classes, I was like, man, these classes are just not for me. I'm just not really interested in this stuff. I can't see myself going 2 more years with all these science classes that I just don't like. So at that point, I decided I'm just going to switch my major to history. Had always really loved history, loved reading, analyzing things. So just decided to go with something that I enjoyed, not something that necessarily was that practical for after undergrad. So fast forward a bit to my senior year at William and Mary and kind of thinking, what am I going to do after I'm graduated from here? And I thought, well, maybe I want to go to law school. With a history major, there's not really any, like I said, any predetermined paths, what you're going to do. A lot of people go to grad school and want to become a college professor or high school teacher or things like that. But a lot of people also decide they're going to go to law school. So at some point in my senior year, I can't remember, end of first semester, start of second semester, I decided I wanted to go to law school. I hadn't taken the LSAT yet at that point, which is something you have to do before you go to law school. So I graduated college in 2001. I moved out to San Francisco, where my girlfriend at the time, who played volleyball at William & Mary, was from. We later got married, but we moved out to San Francisco where she grew up, and did a gap year, I guess, between undergrad and law school. Took the LSAT, studied for the LSAT before that, and then ended up going to law school at the University of San Francisco, out in San Francisco, California. And since I was a former college athlete myself and always loved all sports, but especially college sports since I played them, I thought doing something in the legal world of sports was something I would, probably be pretty interested in doing when I got out of law school. So I took a sports law class at USF. One summer I interned with a guy who was acting as an agent for some NFL players, who got a little bit of experience there. And then when I did graduate from USF in 2005, I went to work for a law firm out in San Francisco called Bingham McCutcheon. It was a big law firm, about 1,000 attorneys nationwide. And one of the clients that the firm had was the NCAA. So that's how I got started in the college sports legal world. I worked on a few cases for the NCAA there. One was called White versus NCAA, sort of a precursor to the O'Bannon case and the Alston case and the House case stuff that's going on now in college sports. So I was at that law firm for about 7 years. And then in 2011, moved to Kansas City, which is near Topeka, where I grew up. And the law firm I worked at initially in Kansas City was another big law firm called Polsinelli. And two clients it had when I got there were the Big 12 Conference and Conference USA. So with the background I had, being a college athlete and already working in the legal side of college athletics, I started working on a lot of matters for those two clients. And there was a lot going on at the time when I was working for those clients, a lot of conference realignment stuff, some other big lawsuits like the O'Bannon case and the Alston case that I mentioned, a lot of TV contract stuff, just whatever legal issues those two conferences had. Then 2019, moved to my current firm, which is much smaller than those two previous firms that I had worked at. So it didn't have some of those built-in client relationships like those other firms had, but I knew I wanted to keep doing stuff in college sports. And it just so happened that it coincided right when NIL was becoming a thing. So I started really paying close attention to everything that was going on there. It was just interesting to me personally as a college athlete, and then all the legal work I had done, really a lot of it related to NIL. And so July 1, 2021, when the rules did change to allow college athletes to start receiving NIL compensation, I was just positioned well with my background as an athlete and working in the legal side of the things that I had previously to really just dive into that world. And there were a number of attorneys who were, pretty well versed in all that stuff, but I was just lucky sort of with the timing of moving to my new firm and when all this stuff kind of exploded.
Amazing. Yeah. I mean, there's a lot of parallels between our stories because I entered college as a biology major also. I pivoted a little bit more quickly than you. I lasted one semester and then in my second semester decided I was going to pivot to being a math major and going from there. So
I did take enough classes to get a biology minor. So I have the history major and biology minor.
I don't have the biology minor, but a good friend of mine worked at Bingham McCutcheon out of college, so I'm familiar with that firm as well. So, with all the talk, and it seems like your path has always gravitated towards sports wherever you went. It kind of aligned great up until the point now of with the NIL situation at Kennyhertz Perry. But with all the talk of NIL and the changes swirling around. What do young athletes and their families need to be aware of?
Yeah, there's a lot to be aware of. Right now, it's sort of a big patchwork of rules and laws that you have to be aware of, especially if you're talking about high school athlete and college athlete. Number one is if you're going to enter into an NIL deal, you need to recognize that it's an actual contract and that you're going to be expected to do the things that it says you're going to do in that contract. And if you don't, there's going to be potential consequences. But also, you need to make sure you're having someone you trust review the agreement that you're signing before you sign it. There have been some examples of situations where athletes have been taken advantage of, especially early on when NIL became a thing. People were excited. I can make money now off of my NIL, so I'm just going to sign whatever someone sends to me. I'm not even going to review it. I'm going to get free stuff. I'm going to get money, so I don't care. I'm just going to sign. And if you do that, there were some examples of athletes signing deals that went for a very long period of time. They were signing over lots of their NIL rights, maybe exclusively to this company or exclusively for a certain category. And if you would have had someone that knew what they were looking for help you review that agreement, you wouldn't have had that stuff in the agreement because they would have negotiated that stuff out. So I think that's probably the most important part is, have someone you trust. Ideally you would have an attorney that knows what they're doing. Not everyone wants to spend money on an attorney. So if not an attorney, someone who has at least some knowledge that can identify some of the potential issues in the agreements you're signing.
Yeah, great. That's great advice. And, the new NCAA agreement that was created recently as college leaders are trying to set the blueprint for the future, increase the number of scholarships per team in many sports, but will decrease the overall roster size of those specific sports. Do you think that in the end, this change helps or hurts the student athlete?
Yeah, what you're referring to is what's known as the House case, and that's a big antitrust class action that just settled. It's going to do a few things. One, as you mentioned, it's getting rid of scholarship limits and replacing them with roster limits. At least this is at the Division I NCAA level. It's also going to allow schools to directly pay NIL compensation to their athletes. With respect to the change from scholarship limits to roster limits, I think that's going to depend on what sport an athlete plays. There's already some examples coming out. Women's soccer is a big one where a lot of teams are way over what the new roster limit is going to be. So they're having to tell people that are still in high school that were committed to a school, hey, we're not going to have a spot for you anymore. Or there are even some examples of athletes who have showed up at school this semester and are then told, sorry, we're not going to have a spot for you anymore because we're going to have this new roster limit. On the other hand, for some sports, they might add additional scholarships for that sport. A big one that people think a lot of scholarships will be added to is baseball. So right now, the roster limit for baseball is 30 something. I think it might be dropping to 27 or something like that. But you can only have 11.7 baseball scholarships, which are usually divided up amongst the whole roster. So everybody's getting, a pretty small scholarship. Like we'll pay for your books or something like that. There might be a few guys, the really good, talented players who are getting more. But everyone on the team is definitely not getting a full scholarship. So that could potentially change if you're a school that really wants to focus on baseball. There could be a lot of scholarships added for that. So I think that the answer to that question is really going to be sport dependent on what sport the athlete's playing.
Yeah, so I think it's one more thing for parents and student athletes to be aware of and cognizant of as they start approaching this process, is knowing how these limits are going to be affecting their sport particularly, and how the new scholarship and NIL could potentially affect that too, because it sounds like it's going to come into play.
A parent Facebook group that's been formed for some of these athletes who might be losing their roster spots, and I think they're actually planning on filing some objections to the settlement agreement. Since this is a class action settlement, the judge has to approve it before it goes into effect, and there's a chance for people to object, the athletes that are affected by it. So there's a movement to, by some people at least, to object to the settlement. So see how that goes.
Sure, with all the fluidity in this space, you're going to be very, very busy for many, many years to come, for sure. So, how have you seen and how do you foresee the transfer portal, influencing the NIL landscape?
Yeah. So the transfer portal, some changes to the transfer portal and NIL, they're two separate things, but they kind of came about at the same time and created this perfect storm of change in college athletics. In conjunction with the transfer portal becoming a thing. So previously, if you wanted to transfer to another school and play another sport, you couldn't just put your name in the transfer portal and be allowed to transfer. You had to get permission from your school. And some schools would say, we're not going to give you permission, or you can only transfer to these schools, or you can't transfer to these schools. The transfer portal got rid of all of that and said, if you want to transfer, put your name in the transfer portal during these times, and you'll be allowed to transfer, to any school you want to transfer to. But now, previously also, you had to sit out a year when you would transfer.
Right. That was the big one.
Which is sort of separate from the transfer portal, but now is part of it. But the NCAA lost a lawsuit last year that got rid of the rule that says if you transfer, you have to sit out. So now, if you transfer, put your name in the transfer portal, transfer to another school, you can play the next season right away. So in conjunction with NIL now becoming a big part of recruiting, when you put your name in the transfer portal and other schools are recruiting you, how much NIL compensation you're going to be paid is a huge part of that recruiting conversation. And that's also allowed now because the NCAA lost a separate lawsuit that was brought by the attorney generals of the states of Tennessee and Virginia that got rid of what's known as their NIL recruiting rules. It said you couldn't talk about NIL compensation as part of your recruiting talks. Well, now you're allowed to have those conversations as part of your recruiting process, and they're, happen frequently and above the table now, when previously they kind of had to be under the table. So it's a huge part of recruiting now. How much NIL compensation will I be paid if I go to your school?
Yeah, so it's become a bidding war in addition to a talent war at the same time, it sounds like. So
exactly.
And this is your opinion. In your opinion, we know that you can't see the future, but do you think that we're going to see a day in our lifetime where college athletes are going to be declared employees of the universities that they play for? Because I know there's been a movement by some of the teams and some of the sports to move in that direction or file legal action in that direction.
So there actually has been one example already of college athletes being declared employees of the university with the Dartmouth men's basketball team. The NLRB already did say they are employees of Dartmouth, and they've actually voted to unionize. So they're currently deemed employees and currently represented by a union. Dartmouth hasn't recognized them as such and is still fighting that through the NLRB, and will probably end up in federal court. But beyond that, more widespread, I do think, whether that's a year, 2 years, 3 years, whatever that is, a much broader scope of at least some college athletes will be declared employees of their universities. And most likely it's probably going to be P4 football players, P4 basketball players, maybe all FBS football players, Division I basketball players, some women's basketball players probably as well. There was a court decision a few months ago that came out from a federal appellate court on this very issue, and they said, yes, some college athletes can be employees under the law, and they created this new test to determine whether college athletes are employees. So now there's also a test out there.
Right.
And they sent that case back down to the lower court where it came from to apply this test to see if some college athletes are employees. So the law is definitely moving in that direction. And I do think whatever that time period is, there will be in the future some college athletes that are employees of their universities and potentially their conferences as well.
Imagine a relationship where financial conversations don't feel stressful, but actually bring you joy. We've designed a guide to help you have positive, meaningful money conversations with your partner. This isn't just another budgeting tool, it's a roadmap for building trust and connection. So if you're ready to start a joyful money journey with your partner, go to mitlin.us/couplesjoy and download your free guide. Transform your financial future together starting today. And I mean, at the end of the day, do you feel that that is more, in your opinion, of course, is that more beneficial to the athlete or more beneficial to the school? I'm assuming the athletes, because they feel like they would benefit further by being an employee. But, in reality, is that, deemed as such or no?
I think there's benefits to both sides. If you're a college athlete and you're recognized as an employee, it means number one, you have to be paid for your time spent working as an athlete. You're also protected by employment laws. But from the university side, it potentially means that the athletes can unionize and then collectively bargain with you. And the benefit of that to universities is right now, all of the legal issues that are swarming around the NCAA, that why they keep getting sued is for violation of antitrust law. And if you collectively bargain rules like compensation limits on how much the athletes can be paid, when they can transfer, things like that, if you collectively bargain those types of rules, they become exempt from antitrust law, which is why, if you talk about the NBA and NFL, they're allowed to have drafts, salary caps, minimum salaries, all those kinds of things only are allowed to exist because of collective bargaining. Otherwise, they all violate antitrust law. And I think with college sports, everyone is in agreement that it's better when you have some structure and some rules around those types of things. The problem is, in the past, it's just been the NCAA saying, here are the rules, as opposed to negotiating those rules with the athletes.
Right.
For a long time, the courts were very deferential to the NCAA and would say, we find these rules do not violate antitrust law. Well, that's shifted a lot since around 2014 with the O'Bannon case. Now they're finding any sort of limits on athlete compensation, the player movement, transferring, like we talked about, these NIL recruiting rules, that they violate antitrust law. So there's really only two ways around that. Either Congress gives you a law that says you have an antitrust exemption, which I am not confident is going to happen. The NCAA is trying to get a law like that now, or you collectively bargain those types of rules. And collective bargaining has some issues right now. Number one, the athletes aren't employees. Under the current state of the law, they have to be employees to collectively bargain. And then number two, if some athletes are employees of public institutions, some states don't allow collective bargaining for public employees. So
right.
For collective bargaining to work on a large scale, the athletes would need to be employees of a private entity and all be governed by the National Labor Relations Act. So that's where potentially being employees of a conference could come in, or there could be new private entities formed by schools to operate certain teams. So we'll have to see where that goes as well.
So stay tuned. A lot of changes coming down the pike, sounds like. So, in this quickly evolving space, I know a few weeks ago you shared that a Wake County judge has ruled high school athletes in North Carolina can profit off their name, image, and likeness. How do you think that this is going to change the landscape for athletes who are really still children? In most cases, they're not adults. Collegiate athletes, most of them maybe leading up to the process, but the majority of them, once they become a collegiate athlete, are typically of the age of majority or very close thereof. Now we're talking about kids who potentially could be as young as 12 or 13 entering this space. How do they navigate that change?
Yeah, so that North Carolina situation was sort of an interesting one. High school athletes at private schools in North Carolina were already allowed to receive NIL compensation. It was just athletes governed by the public high school athletic association. We're not. And as you mentioned, a court said, State Board of Education, your rule that says athletes cannot be paid NIL compensation at public schools violates the law. So now both public and private high school athletes in North Carolina can receive NIL compensation. I think now there are actually 40 states where high school athletes can receive NIL compensation and maintain their high school athletics eligibility. So it's pretty widespread now. There's only 10 states where it's not allowed now. But it kind of goes back to that same point I made earlier. You to make sure you know what you're signing. But if you're a high school athlete, it's obviously something that's new and you haven't had to deal with before. Same with your parents as well. So find someone you can trust that can help you sort of navigate all of this. Don't just sign anything that's put in front of you. And then, just important to look out for those similar types of things that I mentioned before. There have been some examples of businesses that are popping up that seem a little predatory on some of the things they're offering. There's a new company that will give you an upfront payment in return for taking your NIL rights, and then they get to keep a certain percentage of all the NIL compensation you make for a very long period of time. So things like that are just important to be aware of. Yes, money when you're a high school athlete is nice, especially there are some families where it could really change their circumstances. But you just need to be aware of what might come along with taking some of that upfront money.
Yeah, so let's talk about that for a minute, because you said something very interesting where this money could be very helpful to families, right? You've heard the same stories that I've heard over the years, and we've seen it play out in real life, some of them even in the courtroom, in terms of, young people, whether they're an actor or a, athlete of the USA, Olympics team, and, they're able to cash in on their name, image, and likeness, right? And there's a revenue stream that's attached to a skill set that they have. And they're not old enough to be responsible for this money. And it's supposed to be in a protected fashion for them and used for them until they achieve such age where they can be self-directed, if you will, right? So how do we prevent situations like that now that it's going to be probably even more widespread than it has been in recent years, to where you have somebody who's not of legal age, mom, dad, or trusted family member is going to take the lead and take a custodial role financially? How do we protect these youngsters from a nefarious situation there?
Yeah, that's a good question. I know some states have laws, and I think most of them apply to actors, where if you're a child actor and you're making money off of that, there's certain trusts and things that at least a certain percentage of the money has to be put into this trust, because there have unfortunately been examples of where a parent takes all the money and spends it, and the actor, when they get older, there's nothing left from.
Right.
They're the one who was working, but someone else took their money and did whatever with it. So I don't know if we'll see any new types of laws passed that are sort of similar to these laws that usually apply to actors. And I don't know if some of these laws that currently exist in some states are broad enough to maybe apply to athletes as well. That could be the case, but that's why it's probably important for some independent person, money manager, financial advisor, whoever it is, to get involved, who can help manage that process, or someone that the athlete maybe trusts. Obviously, if you're in high school, it's probably hard to go around your parents and have this independent person that's going to help you. That's probably the best option right now if you're facing that type of situation.
I'm truthfully, I don't even know. Like, if you have a 15-year-old that wants to sign or is approached for an NIL deal, are they legally able to sign for that deal on their own, or do they need some kind of parental consent for that?
Yeah, usually in most states, you have to have a parent sign if you're under 18 for that agreement to be effective.
And then are there mechanisms in place for that to be looked at again when they turn the age of majority in a lot of cases, or pretty much if you sign at 15 and you sign X number of year deal, it's a done deal at that point?
That's a good question. There may be some states that have laws that say if you sign something when you're under 18, when you hit 18, you can reopen this agreement potentially. I haven't heard of any laws like that, but some states might have a law like that. I'm actually not totally sure.
Okay. Well, I appreciate the honesty. So, what do you think NCAA, right? They've been this juggernaut for years, right? And I think that this has been over the last couple of years, movement towards, this divergence from away from the NCAA kind of dictating everything, and now people having more of a say. What do you think the NCAA really should be most concerned about as it relates to some of these lawsuits or things that are coming up? Is there something that they should be concerned with that is on their radar?
Yeah, I mean, from their perspective, it's just the continued legal liability that exists. I mean, they don't want to keep getting sued for violating antitrust law and just having all this uncertainty that's been out there for over 10 years. So from their perspective, they would love Congress to pass a law that says they have an antitrust exemption and that college athletes can't be employees, because those are really the two legal issues that are hanging out there right now. They have a lot of antitrust liability, and it's looking very likely that at least some athletes are going to be deemed employees at some point in the future, which just creates a lot of uncertainty because under the current college athletics model,
right,
the athletes are not employees. And so if some are employees, it's going to change things a lot from the way the current model exists. So they would prefer to create that certainty that Congress just helps them out. I'm not confident at all that they're going to be able to get a law passed that says college athletes cannot be employees and that gives them an antitrust exemption. So I think those two issues are going to have to be addressed in different ways, kind of as we discussed earlier.
Right.
But from their perspective, that's their two big issues. And then, with the legal liability, if they keep getting sued and having to pay out huge damage numbers, like with the House case we talked about earlier, they're having to pay out $2.8 billion in back damages over 10 years. Potential liability for all three cases that are part of that settlement was estimated maybe at around $20 billion. So if you keep having these types of big cases like this and you have to pay these huge damages numbers, at some point, maybe you just can't afford these damages and you go bankrupt.
Yeah, that's tough. Yeah. Hey, did I hear recently, I didn't have any preparation for this, but did I hear recently that Jerry Rice was suing like his high school alma mater for not being paid under his name, image, or likeness? Was there something floating around about that?
It's possible, but I have not read anything about that. So,
okay, I was just curious. So listen, Mitt, it's been a pleasure having you on. We ask each of our guests the same final question because we are all about joy on the Mitlin Money Mindset. And that is, what did you do today that brought you joy and put you in the right mindset for success?
I would say three things. So I drove my daughter to school today. I have 5 kids. One who's almost a month old, a 2-year-old, 8th grade twins who are 13, and then a 15-year-old who's a sophomore in high school. And so
all right.
My 15-year-old son usually drives himself to school, but a lot of times I'll drive the middle schoolers to school, and I enjoy just that 5-minute drive with one or both of them to school. After that, I went and got some coffee for myself and my wife at our favorite coffee shop, so it felt good to run that little errand for her and give her some coffee when she hasn't been getting as much sleep as normal with the newborn. And then I also worked out this morning, which always puts me in a good mood and a good frame of mind for the rest of the day.
Yeah. It always makes me jealous when people say they drive their kids to school, because that was a gem for me. I used to love those 5, 10, 15 minutes of driving my boys to school every day. It was definitely a very enjoyable part to every day. So thank you for sharing that. Mitt, we're going to have all your information in the show notes, but if people want to learn more about you, learn more about NIL, or have questions about their own situation and their own family, what's the easiest and the best way for them to learn more about it?
I honestly would say you can just go to my Twitter slash X page, which is just at Winter Sports Law. Talk a lot about what's going on in college sports and NIL there, and you can shoot me a direct message on there as well. So that's probably the easiest way, I would say.
Awesome. Well, listen, thank you for sharing. I appreciate you taking out the time to share a lot of great information about this very timely topic. I know our listeners appreciate it, and enjoy the day.
Appreciate you having me on, and same to you.
I want to thank Mitt Winter for being a guest on the Mitlin Money Mindset. Mitt has combined his love for being an athlete and the law to help athletes everywhere navigate the new landscape of name, image, and likeness. Although this is all relatively new, things are moving at a rapid pace, and the last thing an athlete wants to do is risk their NCAA eligibility or future within their sport. Mitt Winter and Kennyhertz Perry can be found across most social media platforms. All the contact information needed to find them can be found in the show notes.
Thank you for joining us on this episode of Mitlin Money Mindset. Remember, it's not just about the money, it's finding joy in the journey and embracing the right mindset. If you love the show, be sure to subscribe, rate, and leave a review. Don't forget to follow along for more tips and inspiration. Please visit the social links below to connect with Larry or his guests. Until next time, keep smiling, keep thriving, and remember to think about, what did you do today that brought you joy?
The opinions voiced in the Mitlin Money Mindset Show with Lawrence Sprung are for general information only and are not intended to provide specific advice or recommendations for any individual. Past performance is no guarantee of future results. All indices are unmanaged and may not be invested into directly. Investing involves risk, including possible loss of principal. No strategy ensures success or protects against loss. To determine what may be appropriate for you, consult with your attorney, accountant, financial or tax advisor prior to investing. Investment advisory services offered through CWM LLC, an SEC registered investment advisor. Guests on the Mitlin Money Mindset Show are not affiliated with CWM LLC.